As I've looked over a number of years at California bills and resolutions and constitutional amendments, every once in a while I come across some interesting bills that have some interesting or unique provisions, at least in regards to a contrast with some general bill drafting norms, if you will. And this statement isn't meant as a criticism of either a bill's author or obviously the bill drafters at the Office of Legislative Counsel. It's just my view of the bill language because it's maybe something that the average bill reader might not normally expect to find in a bill. So here are a couple of examples I found in the 2022 session. The first example is, while it certainly isn't unique to have a statement of legislative intent, it is unusual to find thereafter a provision that would otherwise be set forth, usually in its own statutory section of a code. Also, more often, legislative intent statements are generally contained in uncodified sections of the law. For example, this one is in the Public Resources Code, and the codified section is the intent of the legislature that all provisions of this division be interpreted to encourage and support the reuse as well as the recycling of empty beverage containers. And then in B, it says that the processing payment for a reusable beverage container shall be the same amount paid for other glass beverage containers, which is not something we would normally find in an intent statement. The second example is, again, it might not be unusual to find a statement of intent in a bill where there's an affirmative statement, but this one concerns future legislation to be enacted. And this is interesting because one legislature cannot bind or compel a future legislature to enact a particular statute. And this intent statement contains a very specific affirmative statement that the office shall allocate funds, which is something we don't find in intent language, but instead in the codified statutes. So here it says that it's the intent of the legislature to enact future legislation to transfer funds to the office to support the Community Power Resiliency Program as described in Section 1 of the bill. It's also the intent of the legislature to enact future legislation to transfer funds as the office shall allocate the funds based on Section 1 of this act to counties, cities, special districts, and tribes. Again, very unique language because it's only set forth as the intent to enact future legislation, which is not something normally done. The third example is another statement of intent. Now, while legislation can and should create things like a work group and give it a specific charge with specified tasks, the mere statement of intent doesn't create the work group, and it certainly can't charge the group without actually completing any specified tasks. So why would we put this in intent language and not in statutory language? So here it reads, it is the intent of the legislature that a working group consisting of policymakers from the legislature, the administration, the Student Aid Commission, segments of post-secondary education, external advocates, and student representatives be convened to evaluate changes to state and federal financial aid. Again, this is something that has no force or effect of law because it's merely a statement of intent. We would normally find this in a code book. The fourth and last example is sometimes we find sunset clauses, which obviously is meant to end a particular statute. However, sometimes they have additional language. It's obvious that a sunset date repeal or extension has to occur before the sunset clause is triggered. So we could simply drop language that says whether the statute was enacted before the specified sunset date. That language is unnecessary. I'm sure there are other examples of interesting but unexpected provisions that we can find in California legislation, but these are some examples that have recently caught my eye over the past few months.